Hi, my name is Ty Hyderali. I'm a plaintiff's lawyer. We concentrate in employment law in New Jersey and New York. So there was an interesting case that was certified, a class action case, and the real issue is if you're an employer and you have a policy that automatically deducts a 30-minute lunch break, what do you do when you have employees who work through that lunch break? What are their rights? What are the obligations of the employer? So Chester County Hospital, which was in Westchester, Pennsylvania, had this policy allegedly in place where they had this automatic policy that docked 30 minutes out of an employee's day for a lunch break. But especially with COVID and the requirements upon hospitals, hospital workers who were non-exempt, in other words, hourly workers, were working through the lunch break. And so this case went up to the courts, to the district court, for a conditional certification of a class action or collective action saying, listen, you can't do this. We're working and we're not getting paid. And the court, without passing any judgment on the merits of the claim, which still needs to be delved into, said, you're right. If this in fact was going on, and if you have exempt employees who are paid hourly, you have to pay them at least minimum wage. And if you're deducting 30 minutes automatically, even if they're working, you're paying them $0 for that 30 minutes of time that they worked, even though you may want to call it a lunch break if they weren't taking lunch. And made special note of these being unusual circumstances due to COVID-19 and how this might be something the DOL is looking into as a matter of interest. So for those nurses working in hospitals who have to work through lunch, you have some rights. This is Ty Hyderali. Be safe and be well.